Good morning, good evening, and good night. You are listening to the Honest Judge Podcast. Honest judgments, honest thoughts. I am one of your hosts, Matthew,
I'm your other host, Jacob.
and today we'll be discussing the Stanford versus Kentucky Supreme Court case.
This case was about a 17-year-old boy in the state of Kentucky that committed a first degree murder. And he was put on the death penalty. And he appealed to the higher court, the Supreme Court, and they ruled in favor of Kentucky letting the minors be able to get the death penalty. But this was overturned a few years later by Roper and Sims. And Matthew, what is your opinion on this case?
Yeah, so for me, I think it's a bit more complicated than just should murderers get the death penalty or not, because I'm in favor of that. And we can discuss death penalty a bit more in detail later. But I think that the issue here is, should a minor be able to receive the death penalty? And for me, it's a bit of a slippery slope, because if we give minors the death penalty, what kind of ruling do we have then? That seems like a sort of, it just doesn't seem right to me, you know?
But then again, he was 17. I think he knew what he was doing at the time. It was a first degree murder, so that means he planned it out.
True, but again, if we look at the law, right? The statutes have always held, up until this point, because there was no precedent for this kind of murder case, up until this point, there had never been a minor that had been successfully convicted of first-degree murder and had actually appealed to the Supreme Court. So there was no real precedent for this. And as far as I'm aware, there was no precedent for this in the state of Kentucky either. So the state of Kentucky courts really, and especially the Kentucky Supreme Court, really didn't have any precedent for this either up until this point.
But then again, this was a serious crime, I believe. He was 17. Yes, we have to draw a line somewhere. But if we don't set an example with a 17-year-old that thinks he can get away with the law because he's a minor, we're going to have more minors thinking they can get away with the law as well.
Well, okay, so two things, two main things here. First of all, the case was actually overturned by the Supreme Court a few years after the original decision. So then I would assume that you're not in favor of the Roper v. Simmons decision.
I am not.
Okay, just confirming before we continue. And then my second thing would be that minors, they're not totally let off the hook whenever they commit a crime like this. They just aren't given the death penalty. They're just not allowed to receive the death penalty.
I mean, you're right, they don't get let off the hook, but what is the worst punishment they can get?
Well, obviously the death penalty is the worst punishment that's givable to an offender. But I think, I'm not super knowledgeable in terms of juvenile sentences, but they are still given hefty prison sentences. And once they are of age, they're moved from juvenile detention centers to actual real prisons. And some of the Constitution does prevent you from being tried again for the same crime. So, I mean, that is an interesting point.
Which is called double jeopardy.
Yeah, double jeopardy. You're not allowed to do that.
But then again, if he's appointed at 17, put on death penalty, death penalties take a time. By the time he actually gets the death penalty, who says he won't be 21, 22 by that time?
Yes, but the point of the death penalty is that so let's begin with I do agree with you, and it's the precedent is that it can take up to 20 years for a prisoner on death row to actually receive the death penalty. But this isn't about when he'll be executed. This is about, can we charge a minor, even if he's 17, with the death penalty, even though he is not of age technically. And the courts ruled in the Roper v. Simmons case that they could not do that. That you're not allowed to do that. But up until that point, the Stanford v. Kentucky case was able to allow that. So I think it just is a term of precedent at this point. At this point, the precedent is Roper v. Simmons.
I agree with you, Matthew, on that one. But then again, he's going to be of age by the time he gets the death penalty. Like you said, it takes up to 20 years. You said it wasn't by the time he got executed, but it really is. Maybe his birthday would have been in 3 months, 3 days, 3 weeks.
So I guess it says we'll just have to agree to disagree on that. I think that it, personally for me, it's got to be. I think I have to agree with the Roper v. Simmons case, just in as much as I think that charging minors with it is dangerous. and potentially really bad. And if the Roper v. Simmons case was overturned, then potentially you could charge, I don't know, a 15-year-old with the death penalty,
But if he committed a first-degree murder, I believe he should.
So you would be in favor of, how young would you say first-degree murderers are liable for that kind of stuff? Not liable for any punishment at all.
15 and older, honestly.
15 and older for the death penalty for minors?
Yes.
But you'd be open, but like, let's say it was a 12-year-old, for the sake of argument, let's say it was a 12-year-old boy, he commits first-degree murder, and he's convicted in a court of law. He cannot be tried as an adult even, he's tried as a juvenile. Would you say that he should be given the death penalty? 12 years old?
12 years old, no.
So what would you suggest as opposed to death penalty in that case?
Life in prison.
Life in prison. So full on, not without parole and everything?
No,
despite his brain not being fully developed?
Well, your brain's not developed until you're 24.
Exactly.
So.
25.
25, sorry.
Yeah, so your brain's not technically fully done, like, growing until you reach 25 years of age. It's not done maturing yet. And so I'm not suggesting at all that 25 should be the limit for using the death penalty. I think that 18 and older should be the limit for using death penalty, as the precedent is set by Roper v. Simmons. But personally, charging anyone, so once you reach 18, you are then given all the responsibilities of adults. You have to pay taxes and various things, although you can pay taxes before that if you live as an independent. Paying taxes becomes a thing that you have to do. You are forced to sign up. If you're a man, you are forced to sign up for selective service, and various other things that you're forced to do in the U.S. whenever you become a legal adult. And then in my mind, along with those responsibilities and also those rights, like being able to vote and things like that, comes the eligibility to be used for the death penalty. Does that make any sense to you? Or I obviously I don't think you agree, but does that make any sense at all?
Yes, it does make sense. But then you go back to that 12-year-old that committed a murder. Who says? Well, honestly, like you said, Blaine doesn't fully develop, so he probably wasn't thinking all the way there. And plus, when you were 12, did murder ever cross your mind?
I can't say that it didn't, personally, but I mean, I think that murder is, or at least the consideration of murder is a thing that crosses human beings' mind quite often. As we are, in my opinion, this is a biblical view here, but that we're all flawed and evil creatures. And even if, actually, changing the stage of the debate a bit here, I think that it can be said that even without biblical knowledge, which I think, obviously, I'm a Christian, I believe in the Bible, obviously, but I think that whenever we're discussing these kinds of political things, you can't lean solely on the Bible, because the Bible is a religious text. And so you can't really rely totally on religious text. You have to have reasoning for your things beyond biblical text. So I would say in this particular case that in terms of, even without biblical reference, I think you can claim that and like observe in the world that people want things that are evil, and they want things that are flawed, like objectively so.
I absolutely agree with all men are evil and stuff. But then again, when I was 12, I was too busy playing with monster trucks and things, so.
Well, that's true. So, again, I would agree with you that, obviously, there are less murders, especially less first-degree murders, committed by 12-year-olds. But in the case that does happen, you have to also consider that. Now, I'm not trying to say the exception is the rule in this case, obviously. But so you're clearly in favor of not giving 12-year-olds a death penalty if they commit murder. But it seems to me that, like, would you be open for parole on that life sentence that you're giving to the
Absolutely. Parole, because I don't want really to spend their whole life in prison, honestly.
Well, but it's just the possibility of parole. So when you say life in prison, a life prison sentence is not really, it's not until you die.
I know.
It's like, I think it's like 30, 40 years, something like that.
I believe so.
So whenever you give a child the death penalty with just the chance of parole, I feel like that's a bit too of a harsh sentence for a 12-year-old. Now, again, first-degree murder is kind of crazy, but I don't think most 12-year-olds are even capable of that, like you said. But again, putting that aside, if it did happen, then we're looking at a like 30, 40-year sentence with a possibility of parole for this kid. Now, I would think that they would likely get parole since they're a 12-year-old, and there's pretty easy, that's a pretty good avenue to get that, but I'm just not sure about that.
I agree that, well, I don't think they would commit a first-degree murder or 12-year-old because I doubt they're going to plan it. I don't think they can be able to sit there, look away from trucks and stuff from a moment and plan a murder out.
Well, okay, so pivoting away from the 12-year-old here, let's move on. So just the death penalty in general, which I believe we agree pretty much on, apart from this specific instance with the 17-year-old. I think that generally, I've stated this already, I think. But the death penalty for 18 years and older, I'm 100% in favor in murder cases. First and second degree murder. Potentially, I'd be open to second degree being several life sentences to ensure that they never get out, like 100 years or something. That way they don't get out for sure, and with no parole. I'd be open to that in some specific cases. But definitely first-degree murder, always death penalty for me.
Yes, absolutely. If any 15 and older, I believe, if they commit a first-degree murder, it's the death penalty. But like you said, on the second-degree murder, I believe it should be 15 to 20 years on the second degree.
15 to 20 years, that's it?
Yes.
Seems like a pretty lenient sentence in comparison to your ideals on...
But if you look at Kentucky's right now, so...
I want to say, Kentucky's particular laws are not incredibly stringent on second degree murders, at least. On first degree murders, it is death penalty is still an option in Kentucky. However, we are seeing throughout the U.S. various states outlawing the use of the death penalty, such as California. Do you have any particular thoughts on that?
I believe that if you don't have the death penalty, well, they're going to look at it like free food, free bed, no rent.
Well, and potentially, but what's the word? Proponents of the removal of the death penalty, or abolishment of the death penalty, I should say, would claim that that the death penalty does not provide a significant deterrent. That if you're going to commit murder, you're going to do it anyway, whether or not you can receive the death penalty. And additionally, they would claim that life in prison is much more torturous and much worse for them. And this is more conservative proponents of the abolishment of the death penalty. They would say that it's much worse for them to live their lives in prison than it would be for them to, I don't know, just the coward's way out, essentially, is how they would put that. Do you have any particular thoughts on that?
Not honestly, but when you was talking about the death penalty in other states, and then are you well, there's the injection, which is a slow, well, not a slow, but
it's
painless.
A rather quick death. It's more painless. So, just quickly interject. I mean, I will say that typically, whenever the death penalty by lethal injection, is given, there are two shots. The first shot is like a I don't even know what it's called, like a muscle relaxant that dulls the senses and removes any possible pain that may come from the drugs. And the second injection is the lethal one. And by the time that they send in the second injection, the victim is more or less not going to have any idea what's going on.
I absolutely agree. But then there's also the second one, which is not outlawed in all states, but in the majority of the states it is, which is the electric chair. It's allowed in Kentucky, Tennessee, Alabama, and some others, which I'm not very for sure with, but the last time it was used in 2002.
Yeah, so I understand that you're mentioning the electric chair. Are you in favor of the use of the electric chair?
I am in favor of the use of the electric chair.
What particular reason do you have for being in favor of the electric chair? Are there any particular reasons, or are you just in general?
I believe if they made someone suffer and when they were dying, I believe they should suffer as well.
So do you think then that necessarily if a murder was judged to be quick and painless, like a gunshot, then would you change the death sentence that you would give versus like a more torturous death?
If it was a gunshot and quick and painless, it would have been lethal injection.
Okay, so you would agree that different murder methods would warrant different means of administering the death penalty?
I absolutely agree.
Okay, so let's wrap it up here. I'm glad we had some constructive conversation and a bit of debate between us. I still am in favor of Roper v. Simmons, but I mean we've got some differing opinions on this one. So anyway, this was the Honest Judge podcast. Honest judgments, honest thoughts. Thank you for listening.